Welcome to today's Explainer. We're diving straight into a really intense and incredibly localized debate right now surrounding California's Senate Bill 262. Specifically, we're going to unpack the arguments coming from the bill's harshest critics, people who are raising serious alarms that this proposed legislation fundamentally threatens public safety. Now, if you follow criminal justice reform, you already know the conversation around bail is incredibly complex. But this specific bill, it has sparked a massive pushback from organizations and local bail bondsmen who genuinely believe it's a recipe for disaster. So let's dive into exactly why they're saying that.
Here's our roadmap for today. We're going to start with the zero bail debate, look at the potential loss of local control, really dig into those public safety risks, touch on some logistical and legal roadblocks, and finally, look at lessons from other states.
Section 1. The Zero Bail Debate. To really get why people are pushing back so hard against Senate Bill 262, we first have to understand the core philosophical clash surrounding $0 bail systems. The California State Sheriff's Association summed up this immediate pushback in an August 2021 letter to the State Assembly. They stated, "We saw the danger in a $0 bail system as defendants in jurisdictions around California were released and subsequently rearrested, sometimes within hours of release on $0 bail. Right out of the gate, opponents are using this to completely center the debate on public safety, framing the legislation as a direct, immediate risk to crime victims and everyday citizens."
Section 2. Losing local control. Beyond those immediate safety concerns, critics argue there's a massive structural flaw in applying this kind of law across a state as vast and diverse as California. I mean, picture your own community for a second. On one hand, you have places like Alpine County, which is a tiny population of roughly 1,100 people, and on the other hand, you have massive, sprawling hubs like Los Angeles County or San Francisco. Critics point out that a one-size-fits-all rule mandated from Sacramento basically lacks the flexibility you'd need to address the wildly different crime environments of these specific areas. It's like trying to put the exact same roof on a skyscraper and a log cabin.
Under SB 262, the Judicial Council would be required to create a statewide bail schedule. This is a mandated, centralized framework, and critics are arguing this effectively strips locally elected judges of their power. The argument goes that local judges have a much better pulse on their own communities, right? They understand their local crime waves, and they know what bail amounts actually make sense for specific local offenses, like DUI bail bonds, based on what's happening literally right outside their courthouse doors. Opponents are saying SB 262 takes that incredibly vital tool completely away.
Section 3, and this is the big one. The public safety argument.
This is where the opposition to the bill gets the most urgent. They argue SB 262 poses a direct physical threat to communities because of what it actively ignores. According to the source material, the bill prohibits the consideration of certain severe aggravating factors when setting this new centralized schedule. We're talking about the use of a gun, victimizing a child, victimizing an elderly person, or inflicting great bodily injury, which, as the source notes, includes horrific acts like mutilating victims with acid or burning them. Opponents argue that legally ignoring these factors puts the public in immediate, undeniable danger. And critics aren't just relying on theoretical what-ifs here. They point straight to empirical data from the California Judicial Council's own Pretrial Pilot Program study from July 2021. This wasn't just a handful of cases either. The study analyzed nearly 3,000 criminal defendants who were moving through the system without bail, which gives opponents some very concrete, very recent statistics to back up their safety arguments.
The numbers from that study are pretty wild when you look at them. Without a bail bond in place, 30% of these defendants failed to appear in court as required. But even more concerning to critics, a staggering 40% were arrested for a brand new offense. Because nearly half of the individuals released without bail went on to allegedly commit new crimes while just awaiting trial, opponents argue this is the proof. They say it shows that releasing individuals without financial accountability directly correlates to a dangerous spike in crime.
Section 4. Logistical and legal roadblocks.
Now, stepping away from physical safety for just a second, opponents also argue that the sheer everyday mechanics of implementing SB 262 would create a systemic disaster. Under the bill's urgency clause, the new rules would demand that courts conduct lengthy hearings for every single arrestee to determine their ability to pay and figure out whether money bail would cause substantial hardship. Critics argue local trial courts simply do not have the capacity for this. They cite insufficient finances, a lack of staff, inadequate facilities, and missing procedures. Basically, they're saying mandating thousands of these mini-trials will bankrupt local courts and plunge the entire justice system into logistical chaos.
On top of the logistics, there's a pretty massive legal argument presented by the bill's opponents. They actually claim SB 262 violates the state constitution, specifically Proposition 103. They point to a 1995 California Supreme Court ruling, arguing that the state cannot enforce actions that result in a confiscatory rate. You see, the insurance commissioner is legally obligated to ensure that rates provide a fair and reasonable return on investment. Critics assert that any legislative action interfering with that duty, which they argue SB 262 absolutely does, cannot be validly enacted. It is a highly complex legal hurdle, but it adds a serious layer to their fierce opposition.
Section 5. Lessons from other states.
The opponents of SB 262 aren't just looking at California in a vacuum, they're looking across the country. They're basically saying, hey, we've seen this movie before, and we know how it ends. They highlight that similar bail legislation has been attempted and failed elsewhere. In Alaska, the reforms resulted in such a public outcry that they had to be substantially rolled back. The exact same thing happened in New York. And in Utah, similar bail reform was repealed completely. Critics frame SB 262 as a repetition of these allegedly disastrous experiments, warning voters that they're heading down a road that other states have already had to abandon.
Which leaves us with a final, overarching question. How do we balance the desire for standardized justice reform with a community's need for logistical stability and immediate public safety? Because as we've seen from the critics' perspective today, the debate over Senate Bill 262 is so much more than just administrative rules. It's a high-stakes battle over local control, the very real limitations of court resources, and, most importantly, the safety of the public in the face of climbing rearrest statistics. It's a hugely complex issue that absolutely demands our focused attention. Thank you so much for joining me for this explainer, and keep questioning what's happening right in your own backyard.